Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everyone, welcome back to an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph L. Jordan, the founder over at Jordan UCMJ Law Group. I am your host, Mike Leon. You know, Joseph here is a former Army, JAG, and worldwide court-martial defense attorney who's tried more than 240 court-martials to verdict. He's handled more than 350 military cases all across the United States, the Pacific, Europe, the Middle East. Today's episode, we're going to be talking about what separates preparation from mastery. Joseph's going to explain how a case comes together once all the facts are available, the personalities, all the variables that are on the table, and how the strategic thinking shapes everything that happens once the trial begins. Joseph, it's good to see you as always. You know, I love talking about this. We were just talking about how I'm A Few Good Men fan. So it's my favorite movie, but I want to ask you because there's investigations that happen in that movie. There's investigations that happen in your world. So once an investigation is underway, what does it really take for you to feel grounded in a case beyond just understanding all the facts that are on a piece of paper?
Thank you, Mike. First and foremost, it's a firm understanding of, one, the written evidence, but more importantly, looking at the interviews of individuals and then conducting my own interviews. Second, moving on and going to the scene of the crime, right? Seeing exactly what happened, when it happened, where it happened. And that can take many forms. You could be looking at digital data. You could be looking at actually walking through a room, walking through the barracks, going out to the scene of a wreck, those sorts of things, walking through the lobby of a hotel or looking at the inside of a vehicle. If they claim that a sexual assault occurred inside the vehicle and the female was 6'1", like in one of my cases, and she wore stilettos, and she said she was raped by two men inside of a truck. Okay, well, I'm looking for evidence that there was a struggle. There wasn't any. Full acquittal, right? So you want to look at all of the finer details of a case, and that means getting your hands dirty in many cases.
And I mentioned in the intro about variables, and some of these variables come in the way of, like you said, right? Combing for evidence, the personalities that are involved in the case. Then you got command climate, you've got the potential panel and what that makeup will be. So like, how do you kind of organize all those variables into a clear mental picture of the case?
Yeah, that's a really big question. I think you have to, you categorize it and you prioritize it and then you meditate on it. You really have to think through. Each jurisdiction has its own kind of way they process information. And then each case has a life of its own. And, the number one question that I get from potential clients is, have you seen a case like mine? And that's a loaded question. And oftentimes they don't realize that, have you won a case like mine? Well, sure, I've seen a similar fact pattern, but no case is the same. And so you have to assess it as its own case. It's one of the things that I really enjoy about this business is each case is its own story. So how does it come together? And so you have to have a spirit of exploration. You have to have a spirit of adventurism. And that allows you to really and truly pull in all of those variables that you asked me about and put them in their right slots.
Speaking of fact patterns, I'm sure some facts or details matter way more than others. How do you determine that? Like which facts are truly central to the case and maybe which ones could be distractions?
So for me, I start with the elements of the offense. So each charge requires that the government prove each element of the actual offense. So there'll be the jurisdictional element is where did this happen? And when did this happen? The act, what was the specific act, the movement, the verb, as it were. And then you have the intent. And so that's where I start. What evidence is there to prove those for the government? And then I turn around and I start to look at, all right, well, I see where the government's coming from with this, or I see exactly where they're deficient. Um, but if there's facts in dispute, then it's an understanding of how to poke at those facts. What do I have to dispute the government's recitation of the facts? What motivations are there for someone to make a claim? For example, if it's a domestic violence case or a sexual assault case, I want to know what the motivations are behind the claim. Right? Is there a history of violence between the two? If it's domestic violence, is this a failed relationship? Is this a side girlfriend? And she found out that my client is married. Those sorts of things. So we really and truly want to start to take things apart at their elemental level to determine what we have to work with.
And in that example you just gave, there's human dynamics at play, also with respect to the panel that's convened, right? So the panel demographics that play such a pivotal role in these trials. So how do those considerations shape the way you think about the strategy and approaching and appearing before this panel before you even step into the courtroom?
Sure. So different branches of the service have different cultures. I can remember stepping into an Air Force courtroom for my first time, and I felt like I was in a much more civilian type atmosphere. I don't want to say it was more professional. Army court martials are very professional. It's just a different vibe. It's a different culture in terms of how they process information. Um, they're much more collegial and nice to each other, whereas the Army tends to be a little bit more direct. Marine Corps is even more direct. The Navy is a nice mix between the services, but even within each service, there's cultures and dynamics. And I'll use the Army for example. I recently tried and won a case for a master sergeant at Fort Leonard Wood, Missouri. Now, Fort Leonard Wood, Missouri, is the home of the engineering corps. It's also the home of military police. So you got two competing cultures there. And I hadn't, and when we start to figure out what the panel looks like, we get data sheets on them. And my panel for that case was full of engineers. And I couldn't remember a time where I had this many engineers on panel. And so I started to think, man, how am I going to talk to these guys? So I went and I talked to the local senior defense counsel. I was like, you've been here for 18 months. Yep. Tell me a little bit about how engineers think. And he did. And so I adjusted my approach a little bit. They tend to be, first of all, Army engineers tend to think they know more than everybody else in the room. They're hyper intelligent. They're very, they do critically analyze things, but they like to put information in each box. Like everything's got a structure to it. They're engineers. And so that does affect your advocacy style to a certain degree. And so I do that analysis for every panel that I go in front of. I think about how am I going to message to them? And you have to do that in order for that panel to know you, like you, and trust you. And the same thing goes for advocating to commanders. You got to be able to speak to commanders as you're advocating for clients in a language that they will understand. So if your client is under investigation and they want to take leave, for instance, you want to be able to reach that commander on their level so that they are more inclined to grant the request that you're looking for.
Piggybacking on that, how do you kind of pressure test some of your own theories on the case and to see if it'll actually hold up under the scrutiny?
I used to be an Army prosecutor, and so the way I pressure test a case is how would I prosecute this? How would I go at prosecuting this case? If I am putting certain witnesses on the stand, how, as a prosecutor, would I cross-examine them? If I'm getting ready to cross-examine a witness that the government's putting up, what would I do as a prosecutor to try and wall off things that I would do as a defense counsel? So I try to put I don't try. I put myself in the shoes of the prosecutor to understand how are they going to come at this case. You cannot try these cases with blinders without thinking about what the opposition is going to do. You have to treat it like a football game or a military operation. You're getting intelligence on the opposition, and there's a number of ways to do that. One, you ask questions about the prosecutor from trusted individuals. Two, you watch them in action. And three, you do the mental energy. You execute mental energy and you think through exactly how you think they're going to come at your case. Um, uh, that's vital.
Well, you mentioned the athletes part of this, and we've talked about this in previous episodes about the mental state of this, mental conditioning, mainly for the people that are involved in the trial, right? That you're prepping, whether they be cross-examined or even on direct. But for you, how do you prepare yourself mentally? So you're sharp, you're disciplined, and you're adaptable, especially once the trial starts up.
That comes with mastering the case file, number one. You master the case file, and then you prep. And it's a significant amount of prep, and I don't believe that there is such a thing as over preparation, but there is a point where you do reach critical mass. And then you have to trust your preparation, and then over time your experience, I've been practicing military law for 19 years now, so your experience will definitely carry you through on things that you didn't anticipate, or maybe that you thought about and dismissed, but at least you thought about it. But the other part of that isn't what you think. The other way that I kind of keep myself sharp is what I do away from the law, right? So for me, it is taking those breaks, kind of cleansing the mind to a certain degree. I enjoy reading. I read a lot. I watch football and I critically think about what I'm watching. I'm watching the defensive line and what they're doing. I'm watching the secondary and what they're doing. I'm thinking about the play calls that are being called by the offensive coordinator and defensive coordinator and why they might be doing things. And so I have a variety of interests that exercise the mind. I want to always be mentally engaged in whatever it is I'm doing, but not necessarily I can overload on the law, right? I can overload on a particular subject, and I need to take a break from it because at a certain point you become apathetic, and you never want to reach that point. If you reach that point, you have to take a step back, and so having those internal boundaries is important, and that's really and truly one of my most important pieces to staying mentally sharp for the courtroom.
Well, let's talk about the prep part of this. So, can you kind of share a case where you did all this prep, all this legwork prior to the careful strategic planning, let's call it, and it made everything in the courtroom feel like you were in control as opposed to being reactive? What kind of stood out to you about the process?
So I represented an army specialist in Germany. This was in Wiesbaden, Germany, years ago, and he was a very unique individual. Uh, he was American, but he was born in Mexico. He went to medical school in Mexico. His father said if he wanted to do things with his life, the first thing he had to do was go to medical school and then work in a mission. He did both of those things. Then he decided he wanted to be in intelligence in the army, and so he enlisted. Ended up being stationed in Germany, and found himself involved with a female, wherein she claimed sexual assault. I was brought in very early in the process, and had an excellent co-counsel. He's out of the army now. He's a judge, and we worked really well together. We saw things eye to eye, and at the very beginning, I outlined what it is that we were going to do and how we're going to do it. And so, first, it was a very careful analysis of our client's story. What happened? We built a timeline of events based off of what he told us, and then in looking at that timeline, we then determined, hey, there's physical evidence out there that can help us and support what we're trying to do. The biggest piece of that was key logs. So I was here in the States. I didn't get to go to the scene of the crime until I actually got on ground about a week and a half or so, or 2 weeks out from trial. If I'm stateside, early in the process, I'll go and we'll walk the barracks. We'll walk the streets. We'll do what we need to do. But in this case, my co-counsel went, he checked everything out, took pictures, and we got the key logs to determine when room keys were swiped, because this was really important to the timeline of events, because my client had went to several different places. And so we wanted to figure out, okay, how did this happen? When did it happen? The other thing that we got were jailhouse calls, and we scrutinized every single one of them. The alleged victim had called her boyfriend. Motive to fabricate. She had a boyfriend. But not only that, what was her boyfriend saying to her? What was she saying to her boyfriend about the allegation? So we listened to those. We transcribed those calls. And then lastly, we had our own client's statement to CID, which we had reviewed very closely. And in that statement, one of the things that he pointed out was, look, she tried to give me a hickey. She did give me a hickey. And you know what CID didn't do? They didn't take a picture of it. They ignored him making that, hey, look at this. And so, yeah, did we feel confident going into the courtroom? We sure did. And we noticed that there were our client was Hispanic. There were several Hispanic members on the panel. This was an enlisted panel. And we made sure we did everything we could to keep those senior. There were 2 sergeant first classes that were Hispanic that stayed on the panel. They were not viced off. And I felt like having them on the panel gave our client a certain amount of comfort, number one. Number two, they're going to understand some of the nuances of the Hispanic culture, how he speaks, how he processes information, those sorts of things. So it was a thorough investigation in this case. Our investigation was so in depth that we were able to find that one of the investigators in this case had lied on another case, falsified information. And the government made the mistake of putting that investigator on the stand. You can imagine what my cross-examination of that agent was like.
Right.
She left the stand in tears. So, yeah, that was many of my cases. I feel very confident walking into the courtroom. You asked me to pick an example, and that's one that I think back on fondly.
Well, it's great insight. And, it funnels into, as we land the plane here on this episode, what you would want people to take away as they've been following this series, and what should they understand as well about how the strategic thinking, like you just mentioned, and during the preparation phase, truly carries over into every decision that's made during these trials.
Just strategic thinking. There's 2 types of ways to look at a case or problem, a battle, a football game. You have strategic thinking, you have tactical thinking. Strategic is the big picture, right? Understanding how all the pieces are going to kind of come together and understanding what the different variables are that come with those pieces. Tactical thinking is boots on the ground. Now, how do I execute my strategy? The tactics involved in executing the strategy. So you have to be able to think on both levels. You have to be able to think on both levels as you're preparing the case. And you also have to be able to think on both levels when you're actually in the courtroom. And you have to differentiate between the two, and you have to keep your eye on the ball, right? We want to score a touchdown. We want to get a full acquittal. What gets us there, right? And don't get lost in the weeds on things that are not important. And so the preparation is key to that.
Preparation is key in everything, in every phase of life. Joseph, thank you so much for the time, the insights. I appreciate it as always, my friend.
Thank you, Mike.
And thank you to everyone out there for listening to this installment of Courtroom Quarterback with attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, do me a favor right now, visit jordanucmjlaw.com. Before you go, like, subscribe, leave a review and comment, or take this episode and share it with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.